topic of my presentation today is protecting assets from the cost of long-term care. And as I was preparing for today's presentation, I want to focus on steps that you can take today. And what's really great about this topic and this area of law is it not only pertains to our clients in terms of what we should be advising them they can do to protect their assets, estate planning, Medicaid planning, tax planning, but it also pertains to us. And we often forget about us when we're doing, our day-to-day work, especially during this hectic time of year. So I definitely thank you all for taking time out of your busy Thursdays to hear me speak about these steps. So what are some proactive steps you can advise your clients and you can handle personally in ensuring that your I's are dotted, T's are crossed in terms of estate planning and long-term care planning? Well, first and foremost, reviewing your estate plan is important. We're going to talk about what steps you can take through that plan to protect your assets from the cost of care, as well as certain pitfalls and delays that could arise if proper planning is not done. And most importantly, it's important to ensure that goals are met for clients and their families. There's no one size fits all in doing this type of estate planning and protecting people's assets for the future. So a lot of it depends on each family situation, which really varies. So what are some basic things, however, that everyone should have? So to start our conversation, I want to go through some basic documents, make sure everyone has an understanding of them. So first and foremost, we're going to talk about a healthcare proxy and other advanced directives. So a healthcare proxy is a document that allows you or your client to appoint someone else to make medical decisions for you or for them. Really, anyone over the age of 18 should have a healthcare proxy, because the moment you become an adult, your parent no longer has the authority to make medical decisions for you or speak to your doctors. Similarly, if you were to become married, your spouse, just by virtue of being your spouse, does not have authority to make medical decisions for you. Same thing for children. So a healthcare proxy allows you to legally appoint someone else to make those decisions if you cannot do so yourself. So oftentimes, if you go into the hospital for a surgery or something, they'll automatically have you sign a healthcare proxy, but that's not a broad healthcare proxy that sort of goes with you throughout life. It usually stays in the hospital records. And I haven't had too much experience, but my understanding is that they usually will not release it to be used in other situations in the future. So it's an important document to have that you hold on to, that you give your doctor to hold on to, and it can avoid certain problems in the future. One thing that I always harp when I speak to my clients is about them being in the driver's seat, how important it is for them to make decisions now so that when they can no longer make decisions, what they want is being done. And oftentimes clients are resistive to that. They don't want to deal with these problems. They don't want to worry about what happens if they can't do certain things. But the more you leave up to chance, or really to New York law, the less control you're having. Clients often think that by doing estate planning, they're giving up control. They're making certain decisions. They're giving other people access. But really, you are staying in control when you can no longer be in control. So who do you appoint? Who do you name as your healthcare proxy? Well, that really depends on the situation. Most individuals will name a spouse, a parent, a child as their agent. If they don't have those individuals or they don't have a good relationship with them, perhaps it's another person, another family member, a close friend. In some situations, even your doctor might agree to be your healthcare proxy, though I'm seeing less and less of that these days. You can only name one agent to act as healthcare proxy, but alternates can be named as well. So that's really for the doctors, so that the doctors are not speaking with two people or having to track down multiple individuals when a decision needs to be made. There's one point person, and then if that point person is not available, the successors come into play. And this healthcare proxy should be told what it is that you want or your client wants. So not only is it an important document to have, but it's very important to ensure that the person who's acting under the healthcare proxy knows what that person's medical concerns are, issues are, what they would or would not want done. Very important document to have. If you do not have a healthcare proxy, and you become incapacitated, what happens? Well, if you're in a certain facility like a hospital or a skilled nursing facility, under New York law, the Family Healthcare Decision-Making Act can come into play, where essentially there's a hierarchy of individuals who have authority to make medical decisions for the incapacitated person. So it's usually like spouse, children, great-grandchildren, parents, siblings, and it kind of goes on like the rules of intestacy. But it only works in certain locations like a hospital or skilled nursing facility. So if you have a loved one who's at home and has diminished capacity and they just need to be brought to their primary care doctor, and someone needs to be able to make medical decisions, that Family Healthcare Decision-Making Act does not work. So then what we see happening is a guardianship proceeding. And this goes when financial decisions need to be made as well. And guardianship proceedings, such as Article 81 proceedings in the Supreme Court, can be quite lengthy. They are a legal determination of incapacity. And then you're leaving it up to the judge in the Article 81 part as to who is going to be the legal guardian of this individual, who is going to be making healthcare decisions. It could wind up being a totally neutral third party if families cannot agree as to who should be put in that position. So again, having your clients be in the driver's seat, make sure that they have these documents and that they're reviewing them regularly is important. With the healthcare proxy, I also always do a HIPAA form, just your standard health information release form. There is one in the healthcare proxy as well, but I found that medical offices often want to see the physical HIPAA form because that's what they're used to. So I think it's an important document to have as well. Next advanced directive is a living will. So a living will is a document that some clients will confuse with a last will and testament, and they're very different. A living will is a document that states and provides direction as to medical treatment and end-of-life decision making when someone is unable to make those decisions themselves. It usually states that if the principal, the creator of the living will, is brain dead, comatose, no hope of recovery, they would not want to be kept alive by extraordinary measures, meaning that they would not want cardiac resuscitation, mechanical respiration, or tube feeding, but they would want maximum pain relief. It's actually not a legally binding document in the state of New York, though the courts have consistently upheld them. And it can be a very important document to have. I wouldn't say it's something to automatically present in a situation, but more so have in the back pocket in case there's an issue between what the family or healthcare proxy wants and what the doctors are recommending. We saw an uptick in the need of using these documents during COVID when people were being put, on life support, and that may not have been their wish, or the decision to taper someone off, things like that. So an important document to have as well. Probably the most important document I'm going to talk about today is a durable general power of attorney with broad gifting authority. So you're all probably familiar with a power of attorney in some capacity. There's a lot of different reasons or uses of a power of attorney. For most individuals during their life, the way that they see this arise is through estate planning, or if they're buying or selling real property and they cannot be at a closing. And their real estate attorney might prepare a power of attorney for them to sign at that closing. For any real estate attorneys in the room, which I'm sure there are a lot, given this is a CLE by judicial title, you might be familiar with creating powers of attorney. One pitfall that I unfortunately see is that people then rely sometimes on that document for everything else in their life. And it might have been a document that was really just strictly tailored to utilize in one specific situation, such as a closing. So let's say that I couldn't be present at a closing and I named my husband as my power of attorney and my real estate attorney prepared it. It might have just been prepared for purposes of that closing. It might not have contemplated my eventual incapacity or future things that might need to be done. So when I'm doing estate planning for a client, we talk about the use of power of attorney sort of in perpetuity after someone becomes incapacitated. And that's where the durability of it comes into place. You want to have a power of attorney that is valid not only while the creator has capacity, but also after an incapacity occurs. Sometimes clients will come to me and say, well, I don't want my power of attorney to be valid now. I only want it to be valid if I become incapacitated. There is a power of attorney that allows for that called a springing power of attorney. Truthfully, I find them to be a little dangerous and confusing in the sense that you then need to have a certain situation arise in order for the power of attorney to be activated. And the question is, how do you demonstrate that situation? Let's say it's incapacity. So now you have a springing power of attorney that comes into effect upon the principal's incapacity. Who's determining their incapacity? Is it a judicial determination of incapacity requiring a guardianship proceeding? Is it doctor's letters? Which doctors? I find that it becomes then this push and pull of, does this person have the authority? Does this person have the capacity? So I usually recommend having a durable power of attorney. What does that mean? It means that then the power of attorney technically is valid the moment it's signed, which can sound scary. It's scary to think of giving someone else authority to handle finances for you while you can still do so yourself. So that's really where the question of trust comes in, and a conversation of who your client trusts to have that type of authority. Most individuals don't want to handle someone else's finances. We have enough to handle with our own finances. So if you have someone that you trust, a child, a spouse, another relative, who can handle your finances for you if and when you cannot, usually them also having that authority when you can is a non-issue. Some attorneys will hold on to the original powers of attorney and only release them if they receive a letter from a doctor. So that sometimes can give the client a little bit more comfort in doing a durable power of attorney. The reason it's necessary is just like with medical decisions. If you cannot make your own financial decisions and you have assets in your name alone, or have, investment accounts, retirement accounts, stocks, bonds, real property, taxes to be paid. There's no one that can handle those affairs for you if you can't do so yourself. So then you're back in a guardianship court potentially if you do not have a power of attorney. The New York State obligations law, general obligations law, outlines what a power of attorney requires. It was most recently updated in June of 2021. Prior to June of 2021, the power of attorney statutory short form had to be explicitly followed, where if there was any error or potential error in even the drafting of the power of attorney as to like a spelling or wording being incorrect, it could technically be deemed void. The most recent updates to the law gave a little bit more flexibility with the document, and it also removed the statutory gifts rider, which was a separate addendum to the power of attorney that gave gifting authority. It was a very complicated document prior to 2021. It's still a lengthy, complicated document, but now all of the authorities, including gifting authorities, can be within the one statutory short form, and gifting authorities are given within the modification section to the power of attorney. So it's very important that you're utilizing the most recent form and that you've created modifications to the power of attorney if your client wishes to give additional authorities above the standard authorities, which I'll talk about in a minute. And that if your client has not updated their power of attorney in a number of years, I do recommend updating it, even if it was validly done under prior laws, prior to 2021 or 2016. The concerns that I often see is that the bank tellers and bankers at, Chase, Wells Fargo, et cetera, are only being trained on the most recent power of attorney form. So if they see one that's fairly old, even though it's valid, you're automatically going to the legal department, going through a review of the power of attorney before you can even utilize it. Another important potential pitfalls with powers of attorney that I see is when appointing co-agents. So under the power of attorney, you can name multiple people to act as your agents at the same time. So you can name one person to act as your agent, you can name successors, you can name 2 people, 3 people to act as co-agents. And the statutory form allows the principal to indicate whether they want those co-agents to act together or be able to act separately. Now, validly or legally, the principal can decide either way, and a bank should allow that power of attorney to be used regardless. We have seen that a number of, typical banks, Chase, not to name names, will only take a power of attorney if the co-agents have authority to act separately. It is their position that it's their obligation to therefore make sure that those agents are acting together if the power of attorney states they have to act together. Now, it's really not Chase's obligation or any bank's obligation to do that. It's the agent's obligation as the fiduciary to ensure that they're following the terms of the document. However, I've seen clients have difficulty and even have to move banks because their bank will not take the power of attorney if it does not specifically indicate that the agents can act separately. Now, certainly there's situations where you might not want your agents to act separately and you want them to be only acting together. Acting together with agents creates a nice check and balance. Let's say you have two kids, and let's say that they have a fine relationship, but you're a little bit concerned, about them doing things independently. You might want them to act together and have to physically make decisions together. If you give them the authority to act separately, child A could do something on a Monday and child B could do something on a Tuesday, and technically they don't have to speak to each other. So it is very important to have a conversation, with your agents as to expectations, and also appoint people you trust when you're making a power of attorney. So the document can be very broad. It can be very simple. Some general provisions to always have included in a power of attorney are things like real estate transactions, banking transactions, business operations. These are all statutory in the document as well. A really important topic or point to make is that all other matters should always be initialed by the principal. This is sort of like a catch-all provision in the standard provision, general provision section, where if something's not specifically indicated in the modifications or in the general provisions, you may still be able to do it as long as it's not gifting. Okay, so some important modifications to add to the power of attorney. First and foremost, the power to gift assets. This, especially when we're talking about asset protection planning, is extremely important. Ideal oftentimes with a population of clients that have some level of diminished capacity. They're elderly, they have medical issues, and hopefully they have powers of attorney. This power to gift assets is frequently utilized to assist individuals who do not have capacity to make gifts of assets themselves in order to move assets out of their name in accordance with their testamentary scheme, giving money to their beneficiaries, what they would want and in their best interest, but get assets out of their name in order to protect assets for Medicaid planning purposes, such as creating and funding an irrevocable Medicaid asset protection trust, or gift assets to a spouse in order to do Medicaid planning, gifting assets out of someone's name for tax purposes to do estate tax planning in New York. So very broad gifting authority is important. The general provisions and the statutory form does give the authority to make gifts, but it's limited in amount. And I believe it's $5,000 that it's limited to. So if you only give the standard provisions, your agent can only gift assets of that dollar amount and only to specific people. So it very much so limits the type of planning that can be done, including the ability to create irrevocable trusts, change beneficiaries on life insurance policies, retirement accounts, add joint owners to bank accounts. All of that sort of comes in under gifting and the modification section. So having a modification section that allows for broad gifting. Oftentimes it's very important that that gifting also be allowed to the agents themselves. Usually the people that the principal trusts to appoint as an agent under a power of attorney is also the person that they would want money going to in the event something were to happen to them or planning needed to be done. So you need to specifically indicate that the agents can gift money to themselves because it's otherwise a conflict of interest for them to do so as a fiduciary. The modification section should also include a provision about trust transactions, the ability to transact assets into trusts, create trusts, revoke trusts, amend trusts even, depending on the situation. Safe deposit box entry is important. Having a provision about retaining attorneys, accountants, personal service contracts, such as having home health aides come into the home for the individual principal under the power of attorney. Statutory elections can be made through a power of attorney. Spousal refusal forms for Medicaid applications are often specifically indicated. The authority to prepare and submit a Medicaid application on behalf of the principal. And also more recently, having provisions about digital assets and devices in a power of attorney can also be very helpful. If a client has a only online bank account and someone needs to get access to it, the agent under the power of attorney may need to use that digital asset provision in order to get access to that purely digital asset. Cryptocurrency, even devices that someone might have, getting access to a cell phone, although very difficult, could be possible through a power of attorney. So probably the most important document to have, again, it gives your clients control and indicates who they would want to be in control of their assets if they were unable to do so themselves. And it's probably the best defense someone has against a guardianship proceeding in the future. Certainly guardianship proceedings where there's valid, robust powers of attorney still occur. And the power of attorney agent is a fiduciary. So if they do something that's not in accordance with their fiduciary obligations, oftentimes the way to get them removed or for certain modifications to happen or for information to be disclosed to other interested parties may be through a guardianship proceeding, but it certainly depends on the situation. So the next document I'm going to touch on before I move into more robust tax planning and estate Medicaid planning, asset protection planning topics is the last will and testament. So I'm sure you all know what this is. A last will and testament is a document that allows you to appoint where or state where you want your money to go when you pass away and who you want to carry out those those wishes, being your executor. Sometimes trustees are also appointed in a last will and testament if testamentary trusts are created under the document. One common misconception that I hear from clients all the time is they do not understand that a last will and testament only controls assets in their name alone on the date that they pass away. So if you have a client that has a joint property, joint husband and wife, that property is not controlled by their will. It goes to the surviving tenant. If you have a joint bank account with two joint owners, unless it's for convenience only or listed as tenants in common, that joint bank account goes to the surviving owner. Those are not controlled by someone's last will and testament. If you have a last will and testament that leaves certain bank accounts to your brother Bobby, but you have named beneficiaries on those bank accounts being your brother Paul, those assets are going to brother Paul because he's the named beneficiary on those accounts. Those get essentially distributed to that person by operation of law. They're not considered probate assets and they're not controlled by someone's last will and testament. The other big misconception I have is that if you have a will, you're avoiding probate. And having a will does not avoid probate. Probate is the process of having someone's last will and testament authenticated by the surrogate's court in the county where the decedent resided at the time of their passing. And it's a process where the executor appointed or nominated in the will can essentially petition the court to get something called letters testamentary, which is essentially what gives that executor the authority to go out and marshal any assets that are in the decedent's name alone at the time they pass away, and then pay expenses, distribute assets to the beneficiaries. So clients often say, well, I have a will. My will says where everything goes. I brought it to the bank, That doesn't actually avoid probate. It just indicates where you want your assets to go. So it's a very important document to have. That being said, many clients do want to avoid probate. Is there anything wrong with probate? No, I do probate proceedings all the time, but it is a process. There are filing fees to have someone's will admitted to probate, there are time deadlines for how long the estate needs to stay open. There's a creditor period of 7 months. So usually distributions with a probate estate are not being made until 7 to 9 months after the person passes away, at least. So it can sometimes delay certain distributions that could be avoided by having named beneficiaries or using testamentary substitutes like revocable or irrevocable trusts. But for individuals that may not care about that, it's important to at least have a will that states where your assets go. So what needs to be in a will in order for it to be valid? Well, there needs to be named beneficiaries and there needs to be fiduciaries indicated. And the beneficiaries can be people, it can be entities, it can be pets, it can be trusts for pets. And beneficiaries can receive a multitude of different types of assets. They can receive tangible personal property, specific bequests of dollar amounts of specific assets, real property. And then what's very important is that you always include a residuary estate. There needs to be a provision that states where whatever is left goes. Oftentimes, this might be done, to specific people in percentages to individuals. It might be to a charity. It depends on each person's situation. There might only be a residuary estate. Your client might say, I want everything to go to my 2 kids in equal shares. And then there's no specific bequests. Everything just gets passed under the residuary after expenses are paid. So the residuary is what's left after expenses, taxes are paid. Other important instructions to include in a last will and testament are if there are minors involved, it's important to have guardians appointed for minor children. Tax implications and considerations, such as how any estate taxes should be handled, what beneficiaries, is it just the residuary that's paying any taxes associated with the distributions, are specific bequest beneficiaries contributing pro rata as to the tax created by the assets they're receiving. I recommend including information or a accumulation trust language for retirement accounts. IRAs, retirement accounts, qualified assets under the Secure Act. Essentially, if money is going to a spouse, there's a lifetime stretch on that income tax liability. However, if you're not a spouse or another designated beneficiary, then, like, for example, if it goes to children, the kids have to withdraw all the money from the retirement account within 10 years and pay all the taxes within 10 years. That's if you have named beneficiaries listed on the retirement accounts. If you don't have any beneficiaries listed and it goes to your estate, then all that money goes into your estate, and typically all the taxes have to be paid within, I think, 3 years. It's a shorter period of time, or 5 years. And then the estate would have to stay open that long. So one way to avoid that is to potentially utilize accumulation trust language where the beneficiaries under the will can still receive the money of the retirement account into their share and still get the 10-year stretch. That's the goal of it. No contest clauses should also be potentially included in a last will and testament in order to avoid a will contest, and simultaneous death clauses as well. So before I move on to revocable trusts, probate avoidance, and then long-term care planning and Medicaid, I just want to touch on what happens if someone dies without a will. So if someone dies without a will, again, New York State creates a plan for them. So it's called an administration proceeding. And if you pass away with assets in your name alone, a interested party, is called essentially it's a distributee of your estate, can petition the court to become the administrator of your estate as opposed to the executor. That person would then essentially have very similar authorities as an executor, but they would then have to pay any expenses and distribute money to the distributees. Distributees are essentially next of kin. So instead of you deciding where your assets go, New York law decides. So for example, if you're married and you have 2 children and you don't have a will and you die with assets in your name alone, your assets under New York law, the first $50,000 plus 1/2 goes to the spouse, and the remaining 50% of the assets go to the children. That might not be what your client wants or what you want. So it's important to prepare estate planning documents, a will that states otherwise, or money could wind up going into the hands of people that you or your client do not wish to receive those assets. So what's a way to avoid probate? So I had said, having beneficiaries listed, joint owners, ensuring that assets are not in someone's name alone is a way to avoid probate. However, sometimes you don't want a joint owner on your bank account, or perhaps there's expenses or taxes that need to be paid, and you want to make sure that there's a vessel that receives assets after you pass away instead of having money go directly to named beneficiaries. An excellent vehicle to avoid probate is by using revocable living trusts. A revocable living trust is a trust that's made for a person establishing the trust, called the grantor, while they're alive, and it's for their benefit during their lifetime. They can be the sole trustee of the trust, and they're essentially the lifetime beneficiary as well. It's like an extension of you. It's filed under their social security number, and it allows them to have full access to all of their money, just like they do today during their lifetime. The benefit of it is that any assets titled to the trust avoid probate, and the trust document can then indicate where that money goes after someone passes away. So you can still have those specific bequests, the percentage distributions, how taxes are being done. Any sort of thing that you could have in a will, you can essentially have in a revocable living trust as well, and also avoid probate. So some common uses for it is to avoid probate, quickly transfer assets to a beneficiary. I also like it because it allows for continuity if someone becomes incapacitated. So let's say that the grantor becomes incapacitated and they can no longer act as trustee of their trust. Their successor trustee can then come in and act as trustee of their trust in order to continue paying their taxes, paying their bills, handling things for them. And that can sometimes avoid needing to utilize that power of attorney with those finicky banks as well. Okay. So turning to long-term care planning and protecting assets for the cost of care. Your first defenses in protecting your assets is making sure that you have a great foundation. You have those estate planning documents in order. You have a power of attorney. You're ensuring that there's people to handle things for you when you cannot, so that there aren't elder abuse issues that come into play. The next layer of that is looking at the value of your assets and what your concerns or goals are. One big primary concern for New York seniors, especially for those of us in Westchester who've created a nice nest egg for ourselves, is how do I pay for the cost of care if I have to go into a nursing home or I need care at home? I don't want my kids to be burdened having to take care of me. I don't have all the money in the world to privately pay or go to the Osborne and live in an assisted living facility. So what are the options? Well, there's long-term care insurance. So some clients of yours or yourselves have maybe purchased long-term care insurance policies to help offset the private pay cost of care. There are some excellent policies out there that were issued a number of years ago where there might be unlimited amounts of money to be paid out or unlimited time. Nowadays, we see that long-term care insurance is usually connected to a daily rate, an amount that they will pay out for either perpetuity or a number of years. The sweet spot to purchasing long-term care insurance really depends on the individual and their individual health. I'd say I'd recommend that you start looking at long-term care insurance in your 40s and 50s if you're interested in purchasing it, if not sooner. Nowadays, they also have a lot of riders and hybrid long-term care insurance policies. So, you could purchase in your 20s a whole life insurance policy and have a long-term care insurance rider attached to it, which can be very insignificant in cost, but provide a potentially large benefit if you needed long-term care insurance in the future. Some clients plan for the cost of care by self-funding. They pay privately towards the cost of their care. Some rely on family, move in with children, other loved ones, and those individuals care for them. They go to nursing homes, assisted living facilities, and some rely on Medicaid benefits in order to help pay for the cost of that care. So the cost of care in Westchester County and the surrounding counties is not cheap. On average, we're seeing that the cost of care in a nursing home is probably closer to that $200,000 a year mark. Most nursing homes in Westchester that I work with, the daily rate for private pay care is anywhere from $525 a day to $650 a day. So if you've created that nice nest egg for yourself, you have your home paid off, you have some money in retirement, and you have investments, seeing 200,000 plus a year get depleted from that account may not be something that can be sustained for a long period of time or at all. The cost of care at home is a little bit less. Those on average per hour rates are a bit outdated. I'm seeing closer to, $25 to $35 an hour, $28 an hour kind of as a starting point. So if you're getting care, 8 hours of care a day, 7 days a week, you might be looking at over $100,000 a year for care. So the question is, how do you tell your clients they can limit the cost of their care, or for yourself? Well, purchasing long-term care insurance, being eligible for Medicaid benefits, or doing advanced planning to protect assets for Medicaid purposes is really the way to limit the cost of care. Before I move into the Medicaid Asset Protection Trust, let's talk about individuals who are eligible for Medicaid. So if someone is eligible for Medicaid benefits, that means that they're not only financially eligible, but they physically need help at home or require skilled nursing care to be in a nursing home. Right now, there is a 5-year penalty period for nursing home Medicaid if you make gifts of assets within 5 years of applying for Medicaid. So what that means is that if someone applies for nursing home Medicaid, the Medicaid office wants to see what that applicant has done with their money over the past 5 years. They do a 5-year audit. And if money was gifted, if property was gifted out of that applicant's name during that 5-year period, and uncompensated transfers, gifts have been made, Medicaid deems that those gifts were made for purposes of qualifying for Medicaid. Now, you can certainly rebut that, and there have been valid, times where gifts were not made in contemplation of Medicaid, but any gift is viewed essentially as a gift for purposes of qualifying. And Medicaid would say, you're not eligible for Medicaid benefits. You had money. Go use the money you gifted away, get that back, and then come back to us, once your assets are below the eligibility limit. There currently is no look-back period, however, for community Medicaid. So for example, if I needed care at home, I needed help with activities of daily living, walking, dressing, bathing, toileting. If I needed help with that and I had $1 million in my name today, I could technically gift $1 million to my dad tomorrow. And as of January 1st, 2025, I would be eligible for Medicaid benefits as long as I financially had my assets below that eligibility limit, which right now is around $30,000. So they don't look back as to what you've done with your money in terms of gifts when determining eligibility for community Medicaid. Back in 2020, they did put in the Department of Health a 2.5-year penalty period for community Medicaid, where they were going to start a look-back period. That, because of COVID and the public health crisis, was essentially delayed, and it's continued to be delayed until now. I have not heard anything as of late, but we're assuming that maybe in 2025 or 2026, they will implement that 2.5-year penalty period, though we have not heard anything to it recently. So I don't know if that's going to continue to be delayed. So these next slides have to do with federal requirements, the nursing home Medicaid program, the 5-year period, and then this slide for you to look at on your own really gives the income eligibility limits and resource limits for a single individual, a couple, or a couple where one person is in the nursing home. And nursing home Medicaid also, and home care Medicaid also allows for spousal refusal. So let's say you have a husband and wife, one person is in the nursing home, the other person is at home. the spouse at home who's well does not need to get their assets below the resource limit. They can essentially be a refusing spouse. All money can go to the well spouse, and the well spouse can say, Medicaid, I refuse to pay for the cost of my spouse's care in the nursing home. You pay for it. And then what the nursing or Medicaid gets back is essentially a right to seek reimbursement from the refusing spouse. But they can only seek reimbursement at the Medicaid rate, which is significantly decreased to the private pay rate. So what do? How do you protect your assets for Medicaid purposes? And how do you ensure that if you need Medicaid, it'll be available? Well, first, there are some exempt assets and exempt transfers that do not create a disqualification period. So like I discussed with spousal refusal, transfers to spouses are exempt from Medicaid purposes. Transfers of assets to a blind or disabled child are also exempt. And a transfer of a primary residence to a caretaker child, a child who lives and takes care of a parent for at least 2 years, can also be exempt for Medicaid purposes, or transfers of property to a sibling with an equity interest in the property. What's not exempt? Gifts or transfers of property for less than fair market value. So when talking to clients, one thing to look at is if they potentially need help at home or in a nursing home in the future, which really includes all of us, and their assets are in a situation where they may not be able to pay for that without significantly dipping into their savings, and they want to preserve their life savings, pre-planning for it is the best way to ensure that you're limiting the cost of care. One excellent planning technique is an irrevocable Medicaid asset protection trust. Think of the trust as this cup. It's an entity that can be created by a client, and they're the grantor of the trust, and they can name trustees that they trust, it can't be themselves, to be the trustees of the trust. The trust is irrevocable, but for income tax purposes, it's a grantor trust. So any income generated by the trust assets is still taxed to the creator of the trust during their lifetime. And for estate tax purposes, it's considered an incomplete gift. So any assets transferred into the trust also come back into the grantor's estate for tax purposes, which allows for a step up in basis to date of death value on assets. So many clients choose to put, for example, their home into an irrevocable Medicaid asset protection trust. The house is deeded into the trust. That starts a 5-year clock for nursing home Medicaid. The creator of the trust still has the full right to live in the house. No one can kick them out. No one can make them pay rent. They still get their STAR exemption, veterans exemption, any exemptions they receive, they continue to receive. If the property needs to be sold, the trustees of the trust can sell the property, put the proceeds of sale back into the trust, and then buy a replacement or downsized property for the grantor to live in. But it does disqualify them for nursing home Medicaid for 5 years. They still get their personal residency exemption as well if the property is sold, which is very helpful, especially for individuals that have a potential high capital gain tax on their property. The benefit of the trust is that after 5 years, whatever is funded into the trust is invisible, essentially, invisible for Medicaid purposes. So it's a way to not totally obliterate your potential exposure to the cost of care, but significantly limit your exposure to the cost of care depending on how much someone funds the trust with. And the trust can be funded with a variety of different assets, real property in other states as well that would otherwise disqualify someone, for Medicaid purposes. Stocks, bonds can go in it, depending on the type of annuity. Some non-qualified annuities may be beneficial to put into an irrevocable trust. I should note that retirement assets, so qualified assets, are exempt for Medicaid purposes. So those typically do not need to be transferred into an irrevocable trust and do not disqualify someone from the cost of care. Any income that's created by those the retirement accounts would, however, the required minimum distribution would be an available income for Medicaid purposes. So there's a lot of benefits.
Pop in really quick. Sorry to interrupt you. I'm just going to pop in really quick and give the code word for the course. The code word is assets. The code word is assets. Thank you.
Thanks, Diana. So there's a lot of benefits to the irrevocable Medicaid trust. Clients often ask me, well, when should I create this type of trust? And a lot of that depends on your client's health and their goals. Usually a sweet spot to do this type of planning for most individuals is early 70s. Once they've become retired, they have an idea of what their income needs are to live after, post-retirement, and they might be comfortable at that time in distributing assets into an irrevocable trust to start that 5-year clock. Depending on someone's health, sometimes we need to do these types of trusts sooner. I've had clients well into their 90s that are otherwise healthy fund irrevocable trusts. But I usually think a good time to start considering doing Medicaid asset protection planning is in your early 70s. And when someone is healthy and not likely to need care at home or in a nursing home. Before I open up for questions, I do also want to touch on estate and gift tax issues. So it's sometimes not a critical issue for individuals. However, as of late, there are a lot of clients that have, potentially New York taxable estates and also have a need for Medicaid benefits, depending on how someone's assets are structured. If they have real property, 2-3 properties that are worth $4 or $5 million, but do not have liquidity to pay for the cost of their care, they might still benefit from doing Medicaid planning and some estate and gift tax planning as well. So some things to consider is that there's the unlimited marital deduction. So spouses can transfer an unlimited amount of assets and property to each other without any estate or gift tax consequences. So gifts between spouses, leaving money to a spouse at death does not create an estate tax issue. For 2024, the unified estate and gift tax credit federally is currently $13.61 million. That is set to sunset on December 31st, 2025. And as of January 1st, 2026, it's supposed to dip down unless it's reinstated into law, which now that we know, who the next president is going to be, there's a likelihood of that exemption staying where it is. The New York estate tax credit, which is an exemption for New York estate taxes only, there's no gift tax in New York, is currently $6.94 million. An interesting thing about the New York exemption is it's not portable. So if you have a husband and a wife that you're doing planning for, it's important to look at the total value of their estate. And let's say that they have a $6 million estate, if one of them passes away and everything goes to the surviving spouse, all that money might be taxable if it goes over the exemption due to appreciation in future years. So doing disclaimer trust planning, tax planning for New York purposes is important because the deceased spouse's exemption, their 6.94, cannot be added to the surviving spouse's exemption. That can be done federally. And especially timely this time of year, annual exclusions for gift taxes. Each person each year can gift $18,000 to anyone in the world, free of filing any gift tax return. So at the end of the year, you may see people making gifts because of the holidays, but also to lower the value of their estate. And they can be made up to $18,000 per person without having to file a gift tax return. Gifting assets for tax purposes also does do Medicaid planning because as you gift assets out of your name, after 5 years, those are no longer considered assets of yours for Medicaid purposes either. So it's important to note, especially for those clients that might be in the middle where they have potential tax issues and they also have Medicaid issues as well. So I do want to open it up for questions, but what do you do now? For you personally, now is a really great time to physically organize your personal and legal affairs. Don't be a shoemaker that goes without shoes. Ensure that your clients have updated powers of attorney, estate planning documents, organize and review all of your policies, and make sure that documents are in place. And if you are interested in doing any sort of long-term care planning, utilizing appropriate vehicles to do so. Medicaid trusts, use of trusts as opposed to outward gifts, have a lot of benefits. Creditor protection, the ability for the creator of the trust to modify beneficiaries and trustees at a later date. So there's a lot of flexibility that can be done when proper planning is done as well. So I'll leave you with my contact information here. I know that we probably have questions in the chat. Diana, do you want me to go through them, or?
I mean, if you want me to, do you want me to read them, or do you want to go through them?
I only see one. Is there just one?
There's a bunch of them. So I'll go through them, and whatever we can get done next.
I see it now. I was in the wrong place. Okay. Is it legally prohibited to have two healthcare agents who might act together? My understanding is under New York law, you can only name one healthcare agent at a time, and then you can name alternates to that one healthcare agent. I agree that there's many situations where clients want children to do things together, and I think it's important to have a conversation with the children then as to what someone's goals and wishes are. I do not often recommend indicating specific wishes in the healthcare proxy because we don't have a crystal ball. We don't know what might happen in the future, but that might be a good way to state, to the children that you want them to act together, what specific medical concerns there are in order to ensure that everyone's on the same page. Next question is, do previously executed powers of attorney need to be updated? What if the principal is now mentally incapacitated? Well, if the principal is incapacitated, they likely do not have the capacity to update a power of attorney. But I do recommend that previously executed powers of attorney for individuals who have capacity, review them and update them, at least every 5 to 10 years or as needed. Make sure that the agents are the people you want them to be, that they're alive, that they're well, that you have a good relationship with them. And if the power of attorney law has changed, it may be beneficial to update your document in order to ensure that the document reflects the last modifications to the power of attorney under New York law. Is the power to gift assets important even for clients whose gross estate is below New York State estate tax exemptions? Absolutely. I'd say a majority of the times I'm using a power of attorney to make gifts is for Medicaid purposes. It's not for people with tax planning. It's for people that want to protect assets and need to become eligible for Medicaid benefits. So there's a lot of reasons for gifting to be allowed, even if there is no tax benefits to it. The next question is, can an agent on a power of attorney write a will for the principal? No, that is virtually the only thing that you cannot delegate to another person, is signing and creating a new will. That's something that has to be done by the testator themselves. It has its own testamentary capacity. The capacity level to sign a last will and testament is very low. It's one lucid moment. So in short, no, you cannot delegate to your power of attorney to write a will for you. Next question is, if you have a valid power of attorney that includes the right to open a safe deposit box, will that be blocked by the bank due to that person being appointed as the POA was not listed on the bank records? So banks really vary in terms of what they'll allow. I think it's important to include safe deposit box entry on a power of attorney, but that does not mean that the bank is going to allow for it. Most of the times nowadays, I'm telling my clients to close their safe deposit boxes. They're not FDIC insured. If someone passes away and owns a safe deposit box, even if there is a joint owner, the joint owner cannot take anything out of the box. I find that as individuals age, they almost create more of a headache than a benefit. So that's how I feel about safe deposit boxes. What is the average cost to a client to probate a will? I mean, I think it depends. Practitioners' costs vary. Some clients or practitioners use a percentage base, a flat fee, an hourly fee. The court costs, the top filing fee is $1,250 for an estate worth more than $500,000, and it sort of decreases from there. Next question is there a priority for bequests in a will? In terms of payout, there is. The residuary gets paid out last. If there's not enough money in the estate to pay out specific bequests, then they essentially get pro rata reduced. So there is, a priority, and there's also a priority as to which expenses are paid first. The next question is, do specific monetary bequests need to specify the source of funds? No, they don't. I don't recommend necessarily specifying the source of funds. People's banks change, people's bank account changes. I don't recommend, I typically do not include the source of funds, like a specific bank account, when making specific monetary bequests. All right, with a trust, when the trust finally ends and principal is distributed to the ultimate beneficiaries, is that distribution taxable? It depends on what it is. Usually a distribution from a trust is not taxable. Like, there's no income tax to the beneficiary on their receipt of the principal. Sometimes they will have to pay income taxes on the income generated by those assets while they were in the trust for the last calendar year. There might be an estate tax that has to be paid first on the assets. So unfortunately, it depends. Let's see. Is the executor of a probated will required to file with the surrogate's court a summary report regarding distribution of estate assets to the beneficiaries before distribution, after distribution, or not at all? No. It depends on whether the estate is being closed informally or formally with the court. If a formal accounting proceeding is being filed, then yes, within the accounting proceeding, a summary of distributions may be included. But many estates close informally with the court, and they might just file the inventory of assets, or they might file the fiduciary affidavit of completion. It depends. Okay. Is there a limit on how much of a retirement account is exempt? So I think this has to do for Medicaid purposes. So as long as a retirement account required minimum distribution is being taken, meaning that a RMD is being withdrawn from the account each calendar year, then the principal value of the IRA, regardless of whether it's $100,000 or $10 million, would be exempt technically for Medicaid purposes. If it's a very large IRA, however, then the income that needs to be paid out might cover the full cost of care in a nursing home, and then that would obviate the need for Medicaid benefits at that situation. Someone asked, wouldn't a life estate for real property be as good, if not better, than an irrevocable trust? Good question. There was actually an excellent article in the New York State Elder Law and Special Needs section about life estate deeds and why they can unfortunately be problematic. Many years ago, that was sort of the standard in doing Medicaid planning for real property. Property was transferred to children. The original owners of the property retained a life estate in the property so that they got a step-up in basis and any exemptions for taxes. And then when they passed away, that property was the children. The issue is that life estate has a value. So if that property needs to be sold and mom and dad are on Medicaid, that life estate value has to be paid back to them, which can disqualify them for Medicaid. The other issue is if the now owners of the property, the children, pass away, mom and dad's property might wind up being owned by in-laws, for example, son-in-laws, daughter-in-laws. There can be a number of issues there. It also doesn't have creditor protection. So if the son or daughter have creditors, a lien can be attached to that property while they're alive. So I think that while they have a time and a reason, we use them a lot for those caretaker child deeds. It's not necessarily what is used as a first option when doing Medicaid planning. So I know we're about out of time. I'm going to answer 2 or 3 more questions. I don't know if, Diana, there's any specific ones that were asked a lot. I don't know if you looked through them.
I did look through them, but in the last couple of minutes, a bunch more came through, so you can choose.
So it looks like there's a few just in me looking at it on step-up in basis with irrevocable trusts. So depending on the type of irrevocable trust, it would either be a completed gift or an incomplete gift. A step-up in basis is only available with irrevocable trusts if specific language is included in that trust that makes it an incomplete gift for tax purposes. So a Medicaid asset protection trust, typically includes that language. And then the step-up in basis would be available when the grantor passes away, so that if those beneficiaries later sold the property, they would not have to pay a capital gain tax unless they sold it for more than what it was worth at the time of the grantor's death. Excuse me. Well, because I'm having a coughing attack,
Sure.
I think I'm going to end here.
Yes. So two things before we go. One, our next CLE will be held on January 16th, and it'll be on fraud, which I know is a very prevalent issue. It'll be about fraud and spotting the red flags of fraud. And two, I will resend everyone the affirmation materials and evaluation. However, I generally clear my whole afternoon to answer questions after the CLE. I do have a meeting. So if you immediately need the affirmation, just shoot me an email and I will forward that out to you. So thank you all for coming. I want to wish everyone a very happy holiday season. We will see you in January. And Lauren, thank you again for a wonderful CLE. You're always interesting and engaging, and we always have a lot of questions. So I want to thank you for your time and expertise.
You're very welcome. If I did not get to anyone's question, my email address is here, and please feel free to email me and I will get back to you with an answer as soon as possible. Thank you again for having me.
Have a great day, everyone.